Good morning, everyone. Welcome to the WILMIC Summer Seminar for 2019. Thank you all for coming today. For those of you that are here in the room, the Wi-Fi network is Wispar Guest, the username is Guest, and the password is Vacation, all lowercase. So if you want to get in on the Wi-Fi, that is it. We have about 110 or so people watching us on the web today. For those of you on the web, thank you for joining us. You can submit a question or a comment in real time to us. The tab that you will find on your screen is in the upper right, and it's called Ask the Speaker. So if you click on the Ask the Speaker tab on your screen, you will get a text box and you can submit a question or comment. We would invite you to do that at any time, and our panelists will then be in a position to answer or comment and reply back to you. So don't hesitate to do that. I would also tell those in the room the same thing. If you have a question or comment, by all means, raise your hand and we will get to you. You can ask that at any time. You don't have to wait until the end of each session. Katya is in the back of the room with the microphone. Give her a couple of seconds to dash over and get you on the mic so that the web viewers can hear your comments and questions as well. This seminar has been approved for 3 ethics credits, so we're good for that. And I think that should do it for housekeeping. If you have any questions, please feel free to let one of us know either at the break or whenever you get a chance. So we're going to cover succession planning today. There's a lot that goes into that, and we've divided it into 3 different one-hour panel discussions. The first panel right now is going to be focused on selling a practice. The second panel, we will focus on merging a practice, and the third panel discussion will be focused more on just closing a practice and what goes into all of that. I think a lot of the topics we talk about in all 3 of those categories, some of it will overlap, and that's okay. But I think we'll try to cover as much as we can for you in those 3 different areas. And again, if there are things that we haven't hit yet or that are on your mind that we haven't talked about, by all means, jump in and we'll try to address that. So those are the 3 panel discussions we have lined up. Each will go a little bit less than an hour, and we'll take a 10-minute break in between each panel discussion, and we will wrap up around noon. For those of you in the room, there is an evaluation sheet at the front of your binder. There should be. If there isn't, let me know, and we'll get you one. And we would appreciate your evaluation at the end of the day before you leave. That always helps us improve and work on future seminars that meet your needs. So thank you for that. Web viewers, you will be getting an email with the same questions to evaluate us as well. So thank you again for being here, both in the room and on the web. We appreciate it. And so let's get started. The first hour is selling a practice. What goes into it? How do you know when you're ready to do that? And those sorts of things. I have a great panel with me this morning. To my immediate right is Tom Schumacher. Tom has worked for 35 years representing closely held businesses. He assists business owners with their personal, family, and business transitions. Uniquely, he also represents several lawyers with their business and estate planning needs. He is the managing shareholder of Bakke Norman in New Richmond. And Tom is also the chair of our WILMIC board. To Tom's right is Dean Dietrich. Dean is shareholder in the Wausau law firm of Dietrich Vanderwall Law Group. With more than 42 years of experience, Dean has practiced in the municipal law area, labor relations, and employment law areas as well. In his practice, Dean has vast experience representing public and private sector employers in the various aspects of employment law and labor relations. And we welcome and appreciate Dean's participation today as well. To Dean's right is Joe McCarthy. Joe is our Vice President of Claims and Underwriting at WILMIC. He has been with WILMIC since 2011. He is the claims manager, was a claims manager with another insurer, and through that position had the opportunity to see how law is practiced across the country. He now serves lawyers across Wisconsin, and in his capacity at WILMIC, he helps them manage their risks and understand their insurance coverage at WILMIC and insurance coverages generally, and that is a consideration too when we're talking about getting out of practice and transitioning and that sort of thing. So Joe brings that valuable insight as well. So that's our first panel, and I'm going to start, before we get into the nuts and bolts of selling a practice, I think we should talk about when should they know that it's the time to do that? How do you recognize the signs that it's time to start thinking about maybe getting out of the practice, and if you have a practice to sell, how do you recognize that it's time to do that? And Dean, I'm going to start with you on that. I know that's an issue you've been working on for a long time. How do lawyers recognize those things?
Well, thank you, Tom, and it's great to be here today. I have been working on this topic for not maybe a real long time, but a long enough time, and it is a very challenging topic. When do you decide to transition? When do you decide? I use the word transition because I think that's the best and the most accurate description of what we're kind of thinking and talking about. I've experienced different lawyers that have talked with me about this topic, and one lawyer decided it was time, or at least he started thinking about it, because he hated his clients. He just had reached a point where there was nothing good about the clients he was dealing with, and it was time for him to look at transitioning. Another situation that I've run into is situations where lawyers just decide that they are no longer having fun engaging in the practice of law. Well, I think I lost fun a long time ago from my recollection of things, but it does become a somewhat of a personal choice. In my situation, I've experienced a heart attack, a stroke, and cancer. I haven't been hit by lightning yet, but you don't see me out in the rain very often, I'll tell you that. And so those caused me to have some real serious thoughts about, well, is it time for me to do something different? And in my particular case, I went to a psychiatrist and said, okay, I had a little problem. It's all taken care of. But am I still able to practice? Am I still safe to practice? And we went through some testing and discussions and stuff like that, and reached the conclusion that I hadn't suffered diminishment, so to speak, to the point that I could continue to practice. And then I had my huge thoughts about transitioning, and probably made the opposite decision that everybody expected me to make. And instead of retiring, I opened my own office, which is a middle ground that we will talk a little bit about in this process today. But Tom, it really is something, there isn't one right way to do it, but more important, my message is deliberate thinking about it and deliberate planning for it. As you had said, I represent a lot of municipalities, and there's no succession planning in local government whatsoever. And you can see the negative impacts it has on trying to run even a business in local government. And succession planning is one of the things that I think lawyers do very little of, especially small firm and solo practitioner lawyers. There's a whole lot of legal issues regarding solo and small firm activities when looking to sell a practice, and Tom, you're going to talk a little bit about that, but even looking at succession planning and emergency planning and stuff like that. But a very personal decision as to when it is time to transition out of your law practice is something that we need to deliberately think about. I had a wonderful conversation with a trial lawyer about 6 months ago, where he admitted to me, I didn't feel at my age I could go into court and do the job I wanted to do the job I used to do as a pure trial lawyer. And he said that made my decision much easier. At that point in time, I decided I need to get out of the business because I'm not performing to the standards that I expect myself to perform to. And that type of thought process, that type of thinking is a wonderful kind of transition into the importance of planning for some type of transition. There just are people, and I'll raise my hand and say I'm one of them, that is not going to transition into retirement. As my wife says, we really don't know what that word means in our home, and I'm okay with that. My wife's not okay with that, but we keep working on it. We keep struggling with it. I happen to think I'm addicted to helping people, and I can't get rid of the addiction. And that's a whole other topic that would take another day to talk about. But it's all part of the mix as we look at what should we be doing. Age 70, back in 1975, is now age 77, according to actuarial tables. So the theory of practicing to age 77 to age 80 is not unreasonable. But there are a lot of intervening factors, particularly if you don't like your clients anymore, it's time to look for something else, Tom.
Tom, from a business lawyer's perspective then, how do you go about analyzing your practice and figuring out what has value and finding buyers and that sort of thing?
I'll talk about that. We'll get into that. I just wanted to comment on a couple of things that Dean talked about. A couple of trial lawyers in our firm have said to me that the same comment that you had, is that they're fine where they are now, but within the next 3 to 5 years, they don't want to be the guy first in line. They don't want to be the first chair. They're more than happy to continue and support, be the second chair on things and continue to work. They're too young to retire, they say, and they don't want to be front line. And as you all know, it takes time to become a good trial lawyer. And so, on our side, we're starting to prepare. We're in the the hiring mode to get people, because it's going to take 3 to 5 years. Even if we're bringing a lateral in, just to kind of get them indoctrinated and get the relationships and all of that. And but that takes time and preparation. And in my role, I said a year ago that in 5 years, I'm not going to be around. I'll be around, but I'm not going to be around in the capacity that I am now. And we need to have somebody that understands. I mean, you would think people would understand this, but we need somebody that knows how to call up the bank and get money in a half hour. And I can do that, but nobody else in the firm can do that. And they said, and I had an episode, it turned out to be nothing in my case, where they thought I had a heart attack at the office, and they, and at that time my wife was working, and she was upstairs working, and I was downstairs working. I stopped working because I was having some problems, and anyway, the ambulance comes and it hauls me over to the Twin Cities. And about the time we got there, I said, I'm really okay now. And all the way over there, I didn't think I was okay, but I think I'm okay now. And so the doctor said, when I got there, they said, well, we could run all kinds of tests, but we can do this angiogram or whatever and find out really what's going on. And so they did that. And so they asked me, what do you want? I said, yeah, go ahead and do that. And so I come out of that, and the doctor walks in and he says, you're going to die, but it's not of a heart attack. He said, you probably got the best looking heart that I've ever seen in my life. So they never concluded what it was. They never understood it. but I can tell you that the other shareholders in our office were a little bit nervous about what was going to happen. So that was a little bit of a wake-up call for us. So there's very...
And Tom, just to comment, I mean, the business planning implications of everything you just said are huge. Assuming you have the goal, and I assume you do, of keeping the firm going. I mean, I can't imagine now sitting down and trying to think about your budget and what your strategic plan is for the next 5 years with all of those factors. I mean, that's a huge issue, huge discussion.
And and the key part of that is keeping the firm going. I mean, we've made the decision, and we talked about, and this is probably 15 years ago, about the process of institutionalizing things so that if we pull one part out of the pie, the whole thing just doesn't collapse on itself. And that is an ongoing effort, and as probably everybody that's listening or watching or here knows, is that, you know what, that's not what we plan on doing. We want to practice law. Everybody in my firm wants to practice law. They're not really much interested in all this other stuff to make sure that they have the ability to practice law, but that's critical, and it's important. So that kind of transitions into me, well, what is it that you do have to sell? And you know, I think about this because I deal with a lot of closely held small businesses, and the question is, do you have anything to sell? Do you have a business to sell, or are you a lawyer, a sole practitioner, and if you're out of the picture, there's nothing there. So there's no systems, there's no forms, there's no plan. It's you representing your clients. You've done it for a number of years. You've got some support staff, and they've been with you for a number of years. And if you go away, there isn't anything else there. You take this file, you work on it, move that aside, take the next one, and maybe you've been doing that you're in a small town, and everything that comes in the door, that's what you handle. And so when you're done, you really don't have anything to sell. And so, as I say here, have you worked on the business or just in the business? And I say that to a lot of small business clients. I mean, what do you have to sell? And so you have to have something to sell, and what is it? So first of all, you've got the office, and you may own your office building. If you've been practicing for 30 plus years, hopefully you don't have much debt left, if any, on that building. So you've got that space, or it's a condo in some larger communities, it could be a condo, or you lease some space. And so that, clients just like us, it's inertia. And if they're familiar with you being in a particular spot, in a particular location, that's valuable because you got the people coming there already. And then if you're leasing the space, do you have a favorable lease? Is it going to be something that's worthwhile for somebody that comes in and take over? Can you transfer those lease terms? You've got a good tenant or a good landlord, so that works. There are people today, probably not those who are in the 30 plus years of practicing, looking to sell their practice, that have no office space. They're just, they're working out of their home. Everything's on computer. Their files and everything is in the cloud. They scan everything, and so they have no location. So then what is it that they have in that category?
And Tom, it's pretty safe to say, I think, that you aren't going to build your retirement plan off of the purchase price or the sale price of that office.
True. That's true.
When I look at, in Wausau, we got a ton of available space. So, I mean, you're not gonna build your retirement plan off that.
That's true. Although the one thing, to the extent that has, you've got equity in that building. I at one time practiced in a building. I was the only lawyer in it. It was part of the firm, but I was the only lawyer in that town, in that office in Baldwin. And that if I'd have been on my own, that would have helped somebody coming in, because they could have gone to the bank. They can, the banks like hard assets like that, as opposed to accounts receivable and work in process. And they could have borrowed against that, got some money to me initially to step back if I was in that situation, or in a solo in a small town, and had that office, and helps some of the financing to get started until they can get in and then start producing some revenue that may be able to pay me back. So from that style, as we all know, at least this is my view of the world, we're only as good as our support staff. And so having people who are experienced in the areas that your practice is, and who are, tech savvy, and, have good relationship with the clients. A lot of times, I've got clients that I've had for, 20, 25 plus years, and although I've had a few paralegals or assistants over that time, that support staff has relationships with your clients, and that's something that's valuable. And so it's valuable if I'm looking at your, if I'm a person looking to buy your practice, it's important to me who that support staff is and what their relationship is with the clients, because I think that's key to transitioning the clients to the next person that's involved.
It certainly is, Tom. I can't take off my ethics hat, and so I need to make this comment. More and more what I've seen are the support staff in a solo or very small firm rendering legal advice based on their experiences. Just make sure that you're not all of a sudden allowing your support staff to be the lawyer in the firm to continue things going forward. I've been very concerned about that.
And that, I'm familiar with that. I hear that, and often have to walk down the hall at my office and mention that. Right. And that's particularly true the more experienced staff that you have. They've been around the block, they understand it. And I often say that, do I want a new lawyer out of law school, or do I want an experienced staff person? I take the experienced staff person all the time. And so that's a factor.
I'm glad you guys are mentioning clients. We do have a question from the web. One of the viewers says, how or when do you alert clients about a potential change? A colleague let her clients know she would be at some point transitioning, and several simply walked away to get other representation, leading to a diminished income that made her transition more difficult. If this is something you could address, I'd love to hear your response.
Tom, I engaged in a long conversation at the Senior Lawyers Division program this past spring on this topic. And first I'll give the ethics answer, and then I think there's a couple of business answers which I think are more effective than the ethics answer. The ethics rules say that you have a duty to communicate with your client, and you have a duty to keep your client reasonably advised as to the nature of the representation, the happenings going on with the representation, and notifying them if there's any change in circumstances, so to speak. There's no particular guidance in the comments about this issue, and frankly, until you can truly say that you're in a point where you're looking to discontinue that representation, and there's a procedure under the 20:1.16 about withdrawing from representation. I don't think there's an ethical duty to tell your client that, hey, look, I'm thinking about retiring in 5 years, or I'm thinking about cutting back in 3 years, or something like that. That's the ethics answer. And as a side note, I didn't think I had an ethical duty to tell my clients that I had a stroke, because I was immediately administered some meds and everything came out fine. From a business perspective, I made all my more frequent clients know that this had happened. I called them up and said, look, this is what happened, in case you hear it on the street. Which you will, yeah. I mean, I didn't want them to hear it from somebody else. So there's a business consideration. And there's a business consideration when you're talking about a transition process and you're looking to phase down in 3 years or something like that. The problem with that, as we talked this through last spring, is once that word gets out, nobody else is coming to you. So I think it's, first of all, I never put it in writing. I don't think you need to put that in writing. And it's a one-on-one conversation with your clients. And I think with your very active clients, you probably want to have that conversation a couple years prior to making, if you will, a more definitive statement. But there's no ethical duty to do that other than if you know that there's going to be a trial in 2 years and you don't intend to be there for trial. I mean, that would be the only consideration from an ethics perspective. But it's a very challenging business consideration. When do you talk about that stuff? And you're right, it can be very harmful to your practice.
Yeah. Joe, as a claims and underwriting guy, you assess risk all the time. How risky is this stuff, and what's your suggestion for how lawyers plan for this?
Well, I think, first of all, I'll go back to something Dean said. I love it. It's deliberate thinking. I'm a big proponent of having a plan. And I was at the Senior Lawyers Division seminar up in Eau Claire where Dean was moderating. And the first panel was 4 or 5 lawyers who had all either already retired or were going through the process of retiring. I was really impressed that every one of them said they started planning this at least 2 or 3 years ago, and some even longer than that. So I think you have to really sit down and think about this, and when to start planning is today. Start putting together the plan today. There's all sorts of reasons to do that. Allowing your clients the opportunity to give that some thought. Maybe you can, to make it not be such a disastrous blow to your business, talk to them about, look, here's my plan. Here's what's going to happen. I hope this plan doesn't go into effect for a couple of years, but just in case, so you know. Because ultimately, it's the client's choice whether they stay with that new attorney that takes over your practice or if they go elsewhere. There is a tiger trap there, I guess, to some extent. It can be a problem for your business. But ultimately, that's going to happen. I think that allowing somebody the opportunity to hear you, sit down with you and talk to you about that and hear what you have to say about it can be comforting to them and can give them the opportunity to really sit back and think about it rather than sort of making a knee-jerk reaction when you decide, hey, I'm retiring, I'm turning off the lights and going home. The other side of that is the unplanned transition out of practice that we get to deal with in some of our claims. It becomes much harder. It's difficult. I can tell you the stories where I've spoken with the widow of a lawyer who has called and said, I don't know what to do with any of this stuff. My husband didn't have a plan. I don't know what to do with these files. That's a very hard discussion to have. It's a very perilous position to have your practice be in, and ultimately it's perilous to your clients as well, because suddenly you're gone. There may be things that are sitting there waiting to be done. Somebody has to come in and take care of that. So from the legal malpractice insurance point of view, we'd really love to see everybody have a plan.
Joe, just if I can take your comments about planning and the thought process and just go one step back. Be honest with yourself. If you're in the practice of law to make money and to build your retirement, and that's it, well, then I don't know that you have to do a lot of planning.
True.
If you're in the practice of law to help people, to work with clients, to solve interesting problems, to assist people, whether it's in a municipal practice helping a local government, or it's in an estate planning practice when you're helping people transition in their life, the clients are most important to you, and the planning process is exactly what allows you to protect and help your clients. And in my particular case, I went to my own firm because I needed to be in a position to successfully transfer someday my clients to somebody else. And where I was at was not going to work, and it was, to me, all about the clients.
On that, kind of following up on that, over the course of the last 20 years, I was counting this up the other day, I think we've had 7 solo practitioners join our firm. And the overriding concern that they had was they wanted to be sure there was somebody there to take care of their clients. They had, as you well know, and as we all know, they had personal, these are long-term clients of theirs. They're in small towns. They've been dealing with, generations of families. And the overriding concern that they have is somebody to be there to take care of their clients. And, that, as you say, that's what's key.
Yeah. Tom, and Tom Watson, I probably should keep my mouth shut here, but Tom, as the buyer, for lack of better words, did you find that to be worthwhile when these sole practitioners came in?
Oh, for sure. I mean, out of those, one didn't work out. And one of the things I've mentioned someplace in here is culture. And even if you're just a solo practitioner, there's still a culture. You have a way of dealing with your clients. You have a vision of who you are and how that works. But, from our perspective, as the firm that these folks merged into, you have a whole another set of clients that you didn't have before. Yeah. The attorney's coming with you, so you have those relationships. One of the things that happened is, and I've heard this from a couple of those folks over the years, is said, well, now we have to do it the Baki Norman way, and so there's some transition from them as to how they did it and to get into our systems, but we've learned things from them as well and changed things as a result of that. But, and I think we have 12, 13 lawyers. We've been as high as 18, and this is the lowest. Well, we started out with 3, so we've fluctuated over the years. But, all of these lawyers were lawyers that we knew. They knew us, and so some of that, things that you'd have to do where you didn't have that relationship would be different. But overwhelmingly for us, that has been a great, and I think every one, even the one that didn't work, I think every one of those would say that was a good deal for them.
Now, Tom, my experiences have not been as positive, so we'll talk about that in a little bit. But did you end up buying the files or buying the practice, or neither? I mean, I'm afraid to some degree it's neither of those. Mm-hmm. But those are all kind of the variations that you can look at.
Sure. And how it worked for us, first of all, we talk about the clients and notifying the clients. And so both, and this happens because we've had lawyers that have come and gone, that, just lawyers that we've hired. And so, there's always a client letter and saying, mm-hmm. This lawyer is leaving the firm or this lawyer is coming to the firm. It is your choice as to who represents you, and we want to give you notice of that. And if you're happy to come with us, or if you're happy to go with the lawyer who happens to be leaving, that's fine with us. Your file will be available. We'll get it to you. And here's kind of the time frame that's going to happen. And so we always have that notice to the client. For those folks that were coming in, they had their accounts receivable, their work in process, and what typically we did is we picked a date and we said, as of this date, you're now here, but we're going to handle all the finances on your files, but all the work in process and all the accounts receivable. So let's talk the accounts receivable first. As the accounts receivable, we're gonna bill all that stuff. We'll get it in our system. It'll get billed. As it comes in, you're gonna keep that, okay? And on the work in process, well, that's gonna overlap, both firms. When that gets billed, we're gonna allocate back to you the work in process that you had before you came, and it's gonna come to us. And then you're gonna be on our system, whatever the arrangement is for that particular lawyer going forward. That's gonna be going forward from that particular date. And so that's how we've done it, and so it's been.
But often, Tom, for the receiving firm, the buying firm, so to speak, you're looking at maybe 5 or 6 clients that, you're really interested in. We didn't have those before, and we'd like to be doing their work. And sometimes that works, and sometimes that doesn't.
That's true.
And so the success of that particular transaction really depends upon both how the selling lawyer who's come in for a period of time and the buying firm, handle that transaction.
Right, and that's true in every one of these transactions, is the ability to successfully transition the clients. That's the key. And, you're in Wausau, which I don't know what the population of Wausau is, but, I'm in Baldwin, that's, 2,500 people. And, a lot of those communities around us are that size. And so for us, it wasn't as much having a couple of big institutional or big business clients going on, but so it became more important. It was really the lawyer, because the lawyer was going to bring those folks, and everybody was going to be with us for at least 5 years after they came. And, once we had the lawyer and once they're in, and then those relationships, then the ability to transfer those become much more likely to happen. And it was very, very, because the existing lawyer, the selling lawyer, continued to handle the clients. But then he'd start bringing in, or she'd start bringing in, somebody else on that file, and you got a period of time to do that.
And the important point here to remember is the selling lawyer needs to understand that he or she is moving to a new culture. And in some cases, moving out of a sole practice where they can do what they want, how they want, when they want. So as a seller, you got to be prepared to do that, which is sometimes a challenge as well.
Giving up control.
All right, we have a question.
Tom, when these sole practitioners bring their practice into your firm, is the deal you make with them that they get to continue to charge the rate to their client as they had before, or do they have to change to your firm's rate structure?
No, they could, for open matters that they had, they would just, the file just continued as it was. For new matters, then it would get into our system, and typically, we were charging more. And, but, it's better that lawyer was telling them that than us telling them that.
And actually, under the ethics rules, 20:1.17, while this isn't strictly a sale, so we would work our way around that, the requirement in the rule is that the fees for the client cannot go up as a result of a sale. So envisioned in there is kind of this philosophy that the client isn't going to be charged more just because there's a sale. While this isn't specifically a sale, that concept applies.
Because if they were charged more, I can see that as disincentive for these sole practitioners to bring their practice to your firm, and that's the last thing you want.
Right.
I think we'll get more into that in the next panel when we talk about merging. I think rate structure is certainly part of that discussion. I want to get back to the selling part of it, but first we have a question from a web viewer, and it's directed to Joe. Joe, the web viewer says, does malpractice insurance cover potential issues that arise after an attorney dies or becomes disabled? Example, attorney dies and an important filing deadline is missed. Who is responsible for the potential harm to the client?
Well, luckily, most malpractice insurance policies, if a lawyer passes away during the policy period, tail coverage automatically goes into place. That's true with us. That's true with many malpractice carriers. So the good answer is yes, there's coverage there for that. Usually It's a bad position to be in, of course, but the company can hire repair counsel perhaps and get someone in to address the issue more quickly than you might think, and be able to repair what has happened, get whatever needs to be filed. So that's part of the insurance. The nice part of an insurance policy is the company will step in, hire repair counsel for that person, and get things moving again.
And Tom, the ethics rules, while this is not black letter, the ethics rules really say that a sole practitioner should have in place, and it's an expectation of competency of that lawyer, should have in place an emergency plan that will go into effect immediately upon some sort of debilitating action or condition or death of that sole practitioner. And typically what that means is that the sole practitioner down the street is called because there's a relationship between those two attorneys, and they've agreed to this between each other, that sole practitioner down the street comes in, looks at the files, takes the immediate steps that need to be taken to avoid missing any of those deadlines or anything like that, and then go through an orderly process of transitioning the files as may be appropriate. That's not a black letter rule requirement, but it is very strongly written into the commentary to the rules. And I know the State Bar of Wisconsin and WILMIC have both published pamphlets about this, so that sole practitioners are thinking through, these are the things that we need to have in place in the event, the old adage is, you get hit by a bus. Well, more likely today it's like I had the stroke. That's the more likely scenario.
And Joe, the WILMIC application asks that very question.
It does.
Yeah.
And it's that duty of diligence, right, to have everything in order in case something happens. I look at it, and I talk to folks that we insure all the time about it. Here's the perfect opportunity to start that transition. If you find another solo practitioner down the road who's a little bit younger, you can maybe start introducing that person to your clients. You can certainly tell your clients about, here's my plan. If I get struck by lightning or if I have a stroke, this lawyer is going to step in. Here's what we intend to happen. You can be setting forth the plan with that lawyer. Are you just coming in to triage the issues? Are you going to take over the files? Are you going to take over the clients? Depending on the disability or what happens to the attorney, it may be that end of the spectrum where the lawyer actually steps into the shoes of that lawyer who's not going to practice any longer and actually take over. But it's a great way to introduce yourself, or your clients rather, to that transitioning attorney.
Although you're not required to communicate that to every client you have. I mean, it's not that, we don't want to misstate that, but it's certainly something that's required for that solo or small firm.
I've had that scenario in that an attorney died, and I got the call. I think I got the call from the state bar, and how they got. I'm not quite sure how they became aware of it, and I literally did walk down the street. We didn't have a relation. We knew each other and actually didn't have many files that crossed paths, but I walked down the street and I walked into the office and not knowing anything, and just had to start and open the file drawer and start going at file by file by file. And that is not a particularly fun process.
It's not a fun thing. And the typical process, quite frankly, is the call comes to the Office of Lawyer Regulation by a complaining client that John died. What's going to happen? And OLR will route that into WISLAP, which will then work with State Bar staff and WISLAP volunteers to try and get something accomplished in order to get some protection. So, I've also had the Supreme Court justices call and say, will you go take care of this? So they pull all their strings.
Okay, we have a question. Michelle, go ahead.
So I'm a business lawyer and I do business transactions, and when a client comes to me and they're selling a restaurant, or a client comes to me and they're selling a service business, I have lots of information about the way those transactions are typically structured and what people can expect in terms of the components of that. I find it very difficult to know in the area of the practice of law what even the options are. So as people talk about planning, I've had a hard time even finding out the myriad of ways in which something can be structured. Certainly I've heard of people joining a firm, I've heard of selling a practice, I've heard of just literally notifying all the clients and handing out the files and closing the door. But there are people that say, well, you could just become of counsel or sell a 1% interest in your... Where are the resources to find out what the options are so you can start to think about which of those might more closely match with what your goals and aspirations are? Because I'm kind of like Dean. I'm most interested in having a home for the clients, but I also don't want to be stupid about what other options might be out there.
Let's break that down a little bit, because there's a lot of different words you can use that all kind of focus into several areas, really. And as far as, first, to answer your question about resources, State Bar, Law Office Management Program, and Ethics Committee have done certain things. I'm pleased to say, as past president of the Senior Lawyers Division, that we're working very closely with WILMIC to put together a comprehensive set of materials that would address this. The American Bar Association has a lot of information as well, a lot of different checklists and stuff like that. But a lot of what you just said are just described are kind of small pieces of some general options. I mean, option number one is to find somebody to come in and, in effect, take over your practice. And in that capacity, you're working to phase out your personal involvement in the practice and looking to give it to somebody else.
And it's just,
Go
as
ahead.
Dean and I
Yes.
spoke about when we were talking about the program, I don't think that happens very often. What's contemplated by the rule that I'm going to take and sell my practice to Dean, and I'm going to stop and not practice law anymore, and Dean's going to take over, and it's going to be done, I don't see that happening. It's typically, it's more in something like we did, where somebody merges with somebody else, or there's a carryover period where Dean comes in and we work together, and then I'm out and Dean's left. But I don't think very often it's what's envisioned in the rule, which is I'm selling my practice, we're going to close on December 1st, Dean's going to take over, and I'm going to suburban Baldwin to retire.
The second option we've talked about and are using a lot of different words, but it's kind of the small firm, solo practitioner merging into a medium-sized or larger firm. You can do that of counsel. There's a couple of ethics opinions on of counsel. The of counsel word is abused more than it's appropriately used, and there really is no real what's appropriate. Of counsel typically means, in a business sense, we have somebody with us who's phasing down his or her practice. I've always been amazed, a fellow ethics person I worked with for many years was in his sole practice. He was in a sole practice and he was of counsel to 2 other firms. And I never understood that, but I certainly believed that you could do that, and you could. But so I've seen it of counsel. The reason I asked the questions earlier is I've seen many situations where the law firm says, we wanna buy the files. Now, you can't technically buy the files and the clients, but what you're gonna do, in effect, is bring those clients into the firm. The practitioner's firm is ultimately gonna dissolve. So it's a place for the clients. You're targeting 1 or 2 or 3 clients. Typically, that's with an of counsel position for a period of 1 year or 2 years. That's kind of how I've seen them structured. And you sometimes set up the structure as the of counsel attorney is going to get a piece of revenues.
Without increasing the charge to the client.
Right, without increasing the charge to the client. The revenues isn't gonna go to the buying firm, it goes to the quote seller. But any new files are handled and transitioned and billed differently. That's kind of the practice that I see the most. I think you're gonna hear a little bit more in the next session about a flat-out merger. Our firm is dissolving and becoming part of XYZ firm. That's what I view as what I would call a typical complete merger. And in that case, you really are joining 2 law firms, or 5 law firms, or whatever it may be. And the other one that Joe kind of talked about is, you get hit by the bus, and that's, the files go out one way or the other.
We only have a minute or 2 left on this panel. Any questions or other comments from anyone? Okay, before we wrap up, and Tom's going to be on the next panel too, and maybe you can touch on some of this in the next hour, Tom, but I know we didn't get to, really putting a value on a firm that you're trying to sell in terms of how do you account for real property, the tax consequences, and accounts payable and receivable and all those things. I know we only have a couple minutes left, and you can't possibly cover all that, but
One thing, a couple things I would just say. In my outline, I talk about, kind of the highlights: support staff, administrative support, all of the infrastructure, all of the business side of it. That creates value. As far as the, accounts receivable and work in process, those, that's not 100% collectible, so there might be some negotiation as to what that is. But most importantly is the goodwill value and the ability to transfer those relationships successfully to whoever the successor is for your firm, and that's really the key. And even if and that's kind of related to the culture thing, and as Michelle talks about, representing small businesses, that culture, the dollars and cents are one thing. But to be successful, it really has to be a culture that fits, because those clients are used to a particular culture. Yeah. And that, whether it's a law firm or it's a restaurant or it's a bar or whatever, manufacturing, it's that culture for those people who are in it. And if you can't put that together, then the likelihood of things turning out well is not very good.
20:1.17, which is our Wisconsin rule, it's a model rule as well, allows for the sale of a law practice, including goodwill. Tom Watson, my understanding is, in cases like that, you get 2 accountants to sit down and look at the practice and look at what's going on and determining what is goodwill. And accountant A says 2 + 2 = 5, and accountant B says 2 + 2 = 8. And then you fight amongst the 2 of them, and somewhere you come to some value that maybe everybody can live with.
Okay. Question, Katya.
I had one question about culture fit, and I completely agree that is probably the hardest and most important part about this. And I guess my question is to Dean: is there anything that prevents you from sending some clients to one firm because you think that culture fit is better, and some clients to a different firm because that culture fit is better for those clients?
No, there isn't anything that prevents that, and in fact, you're required as a lawyer to exercise those judgments in referrals based upon what's in the best interest of the client, more so than your own personal interest. That's the key point to it. And you got to be concerned about the competency of the people you're referring it to.
Okay, we're going to wrap this up. I do want to mention Dean talked about a succession planning guidebook. That is correct. WILMIC is working with the Senior Lawyers Division to put that together. We're hoping to have that done by the end of the year, so you can look for that. At that point, that'll be a free guidebook, and we'll be distributing that after we publish it. So I want to thank the Senior Lawyers Division for working with us on that and for helping us with this seminar as well. And Dean, I'm glad you brought that up. Tom will be on the next panel. If you have more questions about valuation and selling, don't hesitate to ask him. Web folks, thanks for the questions in the first hour. Keep them coming. We'll take a 10-minute break. Let's get back in here at 10:05, and we'll start with panel number 2. Thanks.
All right, why don't we go ahead and get started with our second panel. On this panel, we will focus on merging a practice, as Linda Dellamoro and her husband did when they merged with Von Briesen and Roper. How to find the right partner, what's a good fit, and some of the other checklist items to go through when you're deciding if, when, and with whom to merge. A couple of new speakers. Linda Dellamoro, who I just mentioned, she joined Von Briesen and Roper as a shareholder in 2015. She and her husband Hector were Dellamoro and Dellamoro in Elm Grove, and for many, many years. And the opportunity arose for a merger, and they pursued it. And then also to her right is Aviva Kaiser, who many of us know as the kind-hearted soul who fields all of our ethics questions when we find ourselves in trouble. So she is ethics counsel at the state bar, of course. As we sort of draw the line between... Oh, yes, I am. Thank you, Tom. I'm Matt Beyer. I'm a claims attorney with WILMIC. I've been here for 3 years. It's a fantastic place to work, a fantastic place to interact with colleagues, and really just to sort of keep our fingers on the pulse of Wisconsin attorneys and what their needs and wants and desires are as far as risk management goes, insurance needs go. It's a wonderful place to be, and I'm glad to be there. And thank you, Tom, for reminding me to introduce myself. As we draw the line between selling a practice, which was the focus of our first panel, and merging a practice, Aviva mentioned to me during the break that she wanted to clarify what you may or may not be able to do once you sell a practice. So with that, I'll hand it over for a quick introductory comment from Aviva.
Thanks. So you know the ethics person always putting the kibosh on everything, right? Sorry. So just keep in mind under 1.17, SCR 20:1.17, when you are selling a practice, you as the lawyer cannot continue to practice. You can either sell a part of your practice or you can sell the whole practice. But 1.17a is really clear. The seller ceases to engage in the practice of law or in the area of practice that has been sold, in the geographic area or in the jurisdiction in which the practice has been conducted. So I think we started veering off into ideas about succession planning where the lawyer can continue to practice. Keep in mind, if you're doing a straight sale, you're prohibited from continuing to practice. And I think Joe will talk to you, if you have that tail policy because you've sold your practice, if you continue to practice, what happens?
There's no coverage there.
Yeah. So I think a lot of, we were talking about lawyers, moving their practice somewhere else, which is really the merger part as opposed to a straight sale.
And so with the merger, you can continue to practice.
Right, with the merger, which
That's
is
the
why
option.
it's more, palatable probably.
Okay, so mergers come up in many different ways, and three. I try to give silly titles to each of the three ways that most often come up from our insured attorneys. The first one I call is sort of the Plan B, where the associates in the firm whom you were grooming become interested in other pursuits or leave for other reasons, and so there's no one there, left to carry the ball, so to speak. So there's the Plan B idea. There's also sort of the Godfather offer idea, where another firm or a bigger firm comes in and makes an offer that you can't refuse. And it's one that you want to consider and pursue. And then a third is just one that makes sense, where there's a strategic alliance, because of practice area, because of personality. It's somebody that you've always wanted to work with in some way, shape, or form, and you figure out a way to do that moving forward. So I know that Linda has experienced maybe a blending of each of those, the Plan B and sort of the Godfather, and well, maybe all three in the strategic alliance. But I would invite her to share her experience and what she went through and the thoughts and considerations she had in her merger.
Sure. To give you some background, my husband and I ran a firm for 30 years. We were located in Waukesha County. We had an office in eastern Waukesha County, in Elm Grove, and another office in Delafield in western Waukesha County. My husband's practice was principally municipal law with some employment law and education law. I joined him after teaching school and selling real estate for 10 years. I went to law school belatedly, and we formed Dellamoro and Dellamoro. Everyone advised us that spouses should not practice together, that it would be ruinous for our marriage and terrible as a business plan, but it did work out. We'd been married 13 years, and we knew it would be something we could handle. We kind of kidded that he was the long-range planner and I was the short-range planner, but it all seemed to fit together. We had different practice areas. Mine were estate planning and real estate, so we weren't together constantly that way. He had a lot of evening meetings, and we felt we'd never see each other if I was practicing downtown and he was in meetings all evening, as he usually was. We typically had 2 associates working with us. We typically had 2 legal assistants, law clerks, part-time bookkeeper, and it all worked out fine. We always thought we would have a successor with one of our associate attorneys, but it just never happened. Whether it was the evening hours, whether it was just the demands of running a firm where people had families and other things they wanted to do. And we had people where Hector felt he had invested a lot in training them, and they went off to the Milwaukee Corporation Counsel's attorney or the Eau Claire Corporation Counsel's attorney or larger firms, and things like that just kept happening. And we got to our 60s and we decided this wasn't going to work out. There wasn't going to be a successor. We certainly didn't want to just close up the firm. We were enjoying practicing. We wanted to slow down, but we wanted to keep practicing, and we felt that there was so much goodwill. We did not want our associates just to let them go. We didn't want to let our clients down because so many of them we'd worked with them for years. They'd been friends. They were the municipalities we had lived in. And so we started to look toward the idea of a merger or combination. We did it by putting together a list of possible merger partners, and we looked mainly for who would we like working with. We were looking at small firms in Waukesha County. We were looking for firms that had similar values, similar culture to ours, things that people talked about here. And then we made some phone calls, met with firms and talked to them a little bit to see if it looked like it would be a good fit with our practice areas and what we were hoping to accomplish, what they would like to accomplish. One firm that we had on our short list was a firm that didn't match the others because it was in Milwaukee County and it was a larger firm. But when we contacted an attorney we knew well in that firm, he was very enthusiastic and said, "We've opened a government law practice that my husband would be a great fit in." They were looking to expand in Waukesha County. They hadn't as yet. And they'd like to meet with us right away. So we went down, met with the senior partner in Von Briesen and Roper, Randy Crocker, and right away we knew that was going to work out well. We had a very good meeting and followed up with a few more meetings. And some of the things we talked about, first we ran all of our clients through a conflicts check because we had to make sure that wasn't going to be a roadblock, that there'd be just too many conflicts that it wouldn't work out, and we found out that wasn't the case at all. We talked over our staffs. We let them know what our legal secretaries, what our associates were paid, vacations, hours, those type of things. Looked like a good fit, wasn't too far off from what Von Briesen had been doing. We contacted WILMIC. We had been initial shareholders, bondholders at WILMIC, and we wanted to make sure we'd have no problem with tail coverage, and we found out that would not be a problem. I understand now the Von Briesen firm does have an insurance carrier where they may be able to offer tail coverage to any firm that joins, to some firms that join with them at least. Our role with the firm would be as economic shareholders, which is the term Von Briesen uses, and we would be compensated a percentage based on the work we bring in and a percentage based on the work that we actually do. We would sell our furniture to Von Briesen. We thought we would sell our library and found out that a library today has virtually no value, so our books ultimately, the Elm Grove Library book sale annually had a lot of wonderful Wisconsin Reporters that they sold for decorations, basically. And a lot of books wound up in the dumpster, which was sad. But as we went through all the plans, in terms of our offices, they would take over the lease on our Elm Grove office. We owned our Delafield office, and they would rent that from us for 5 years as we would continue with the firm. New computers, scanners, copiers were installed in our offices. We received Von Briesen laptops and phones, and in June 1 of 2015, we became members of the Von Briesen firm, and we sent out a letter to all of our clients. It was jointly drafted to inform them that we had joined the firm, and if they wished to, they could become clients of the firm. We didn't get any objections to that. All of our open files became Von Briesen files, and we retained in our own storage our closed files until any point in time that we might reopen those files. Our biggest challenge was moving toward digital file retention. As a large firm, Von Briesen had a paperless philosophy and policy, and we had nothing but files with hard copies, and so the scanning began and continues to this day, and in theory we're paperless, but it's something that we're progressing toward really than an accomplished fact. We are now, my husband and I are now practicing in Von Briesen offices in Waukesha. They have opened a separate office with other attorneys in Waukesha County. We feel quite re-energized and enthused. We have enjoyed having so many colleagues after having practiced in a small firm with ourselves and a few others for so many years. It feels great to know that if we're on vacation, there's someone who will take over, that there are people who can handle almost any area where we may need assistance in, that there's quite a large support staff, especially IT support staff, that we can turn to. So it's really been a very positive move for us. Since we joined the firm, a number of other firms larger than ours have joined Von Briesen, and it's been a very smooth transition. I think the cultures have worked well together. We're enjoying working with both the initial partners we joined with, but also many of the new partners. Our staff has stayed with us. Our clients have stayed with us. I think they appreciate the fact that we're with a larger firm. I know someone brought up the thought of higher fees, and yes, gradually we have moved our fees up to more of the downtown firm fees than small town firm fees. But we take into account situations where we've been working with a client for years and make adjustments as we need to. But we find that it's all working out quite nicely for us. Now we're 3 years into the process, and we don't know how much longer we'll continue to work, but if anything, probably longer, because we feel we have more flexibility, but we also have the ability to take time off, take vacations, play golf, things like that. So that basically is our combination story.
That last comment, leads me to, I know that Tom has a question from the web audience that may dovetail nicely with that last comment. Tom, if you want to go ahead and offer that question.
Yeah, thanks, Matt. So the question from a web viewer is, more of a comment, and they would like to hear the panel's reaction. The viewer writes, a couple of my friends have found larger firms to transition their practice. The new firm gets new clients, the retiree gets to wind down and be of counsel for a while. That seems to work pretty well. They're interested in comments from the panel on that.
I think that is a common scenario. I mean, that's what we've had with solo practitioners that have joined our firm, is that they've had that ability to transition, as you talked about, Linda, and that's been common for us. And nobody's really ever, we've never we've had an of-counsel relationship, but not with one of those attorneys. They've generally just stayed with us until they were ready to retire, and then they were done and didn't really stay on as of-counsel when they actually finished practicing.
And I would say, based on my experience, we did not say we'd be of counsel, but when our clients got this letter, they all almost panicked, and suddenly I had so many estate plans I had to update, and so many clients I had to reassure that we weren't walking out the door in the next week or two, and that certainly wasn't our plan. And so, you know, but once clients have come in, they've felt very comfortable knowing that there will be younger clients and more attorneys that we're working with. So I think that although there was the initial panic, they were all very comfortable with the thought that there would be an overlap and their files would be taken care of, knowing that we were now in our 70s and ultimately would be retiring.
Linda, just on the nuts and bolts of it a little bit. So you had all these client calls. So when this occurred, did Von Briesen keep your phone numbers?
Yes, they did.
Okay.
And that was, you know, very important, was we were able, and to this day, still have our Elm Grove phone number coming into Von Briesen, although, you know, we're trying to transition them to call the attorneys directly rather than go through a receptionist, but that original phone call number is still active.
And then what about, you talked about your staff all came over, so that
And they were all very pleased to.
Sure.
Yeah.
And then what, did you have a website, and what happened to the website when the transition?
Our website immediately announced that we had transitioned with them and gave that information and flipped them over to the Von Briesen website.
Okay.
Tom, do we have one other question?
Yeah, follow-up from another web viewer. How does tail coverage work for the merged firm?
So there's two ways to approach it. Tail coverage gets thrown around as this loose term. Everybody understands it, at least they think they do. There's two ways to approach it. If someone merges with a firm that we insure, we could say to the firm, we would offer these new attorneys prior acts coverage. That means that the firm is then going to add all of that risk from those attorneys and their prior work to their current policy. As a result, what I see, the vast majority of firms don't want that. They don't want to accept all of the risk that's out there from somebody's practice from 20 or 25 years of practice. I'm going to suddenly add it to my insurance policy. I don't want that. Companies may do that. Actually, companies will do that. We take our direction primarily from our policyholder, and if they say, we've got these two new attorneys coming in, we'd like to give them prior acts coverage, we generally do that. But again, the vast majority of firms just don't want to take on that risk. The other side of it is what everybody refers to as tail coverage. And it's not a standalone policy. It's an endorsement that somebody buys that attaches to that last policy that was in place. Aviva commented about once that tail coverage is in place, what happens? So the tail endorsement, an extended reporting period endorsement, goes into place on that policy on a certain day. It's only going to cover work that was done before it went into effect. So any work that you do today and into the future isn't going to be covered by that policy that was in place. It's going to be covered by somebody else's policy, i.e. the new firm's policy. So those are the two approaches. Prior acts coverage from the company of the firm that you're joining, or you're buying tail coverage from your current carrier as you walk away, and so that you compartmentalize the risk. All of the risk from the past firm over here with tail coverage, or over here with the new firm with prior acts coverage.
Okay, so I know that Tom had a somewhat different experience, but before we get to that, I wonder, Aviva, if you could comment on some of the, what do the rules require or permit along the way. I know that Linda mentioned client communication, obviously under 1.4. She also said that one of the first things that they did was check conflicts.
Right. So unlike selling a practice, which is governed by the specific rule 20:1.17, there is no specific rule designated for merging practices. So there's a number of rules you want to look at. First, confidentiality. So as Linda said, the first thing they did was run their conflicts check. Our conflicts rule, or our confidentiality rule, was amended, and so under SCR 20:1.6 C6, you may now disclose client identity to detect and resolve conflicts. And you can do that. The model rule is different from ours. The model rule allows that if you're moving between firms or if firms are merging. Our rule even allows that for within the firm. So if you're taking a client in your firm now and that client, there may be a conflict with another existing client, you can, in most instances, reveal that identity to detect and resolve those conflicts. Now you want to be careful because there are sort of three situations where you don't want to reveal that information. One is if it's a merger and acquisition of a company and your law firm does that, and just by merely revealing the name of a client, that could damage a deal, so you wouldn't want to do it there. People who do white-collar criminal defense will often be hired by clients while they're being investigated, but no charges have been filed. And so merely revealing the name of that client could cause issues, so in that instance. And also in family law cases where a spouse does not know that their spouse is filing for divorce, and especially because of domestic violence, we get really concerned, so oftentimes we won't reveal the name of that person. So those are the three instances you really want to be cautious about. But other than that, you can reveal client identity to detect and resolve conflicts. So if you were doing a merger, that would be fine to do that. Communications with client, she mentioned. It's interesting because I included an ethics opinion that says in the materials that you don't have to get client consent when you're merging, but the client should be informed of that. Now, when you do it, isn't really clear from the rules. There are a couple times that are really crucial, though, is if you're merging with a firm and you know that may create problems with your clients. In other words, your clients may not want to go to a bigger firm, or your clients, the culture of that new firm may not work well for those clients. You want to let those clients know that. And then the conflict of interest we talked about in terms of confidentiality, but just keeping in mind how you look for those conflicts. One of the biggest one, and I don't know if you saw that, was positional conflicts, because those are really hard to capture in your database. But some of the cases I saw that in those mergers, positional conflicts come up. And they are covered in Rule 1.7. There's an ABA comment that follows that rule that specifically deals with positional conflicts. So just be aware of that as well. And then another one, did you want to add anything to the conflicts?
No, in our situation, I think because we were in Waukesha County and we, had, not that many corporate clients, it wasn't a situation where we ran into any situation that couldn't be dealt with easily.
Good.
Real quickly, Aviva,
Sure.
you mentioned that we should be concerned about the three situations you described with respect to confidentiality. What does that mean? Does a non-disclosure agreement cover that concern, or is there some other way to go about that?
No, you can't even disclose it.
Okay.
So that's the rule. And there's often times where, client identity is usually not covered by attorney-client privilege, but there are some instances where it may be. And so you just, at that point, look through that database to see if there's any names that you should not disclose. At least, and it may be that if the other firm discloses information, then you can look without disclosing information about your clients. So in other terms of conflicts of interest, keep in mind that you can get waivers, but our screening rules, and I did attach a screening memo to your materials, that our screening rules in Wisconsin are not as broad as the model rules, and so if you've done any more than minor and isolated work on a case and you take that case over to the other firm in merging, you could be typhoid Mary. You could be conflicted out of both cases. So it's a good idea to make sure that not only you denote the type of the case, but the work you did. Restrictions on right to practice has come up in some cases, because oftentimes if a merger fails and you're talking, you've asked and I don't know if you did this, Linda, did you sign a confidentiality agreement at the beginning of the process?
Yes, we did.
Yeah. So, and in that confidentiality agreement, oftentimes you agree not to go after certain lawyers in the other firm. And then, but if you look at Rule 5.6, that prohibits lawyers from making agreements that restrict their right to practice, you want to be really cautious about that.
Okay.
I'm not putting the kibosh on stuff.
Yeah, right.
Sorry.
So mergers aren't always successful, and I understand that Tom has had some experience where some mergers were explored and just maybe didn't work out as well, or had reasons not to pursue.
So I can talk about that a little bit. I just want to mention, I said earlier that we've merged some sole practitioners into our firm, and to follow up a little bit on how you handled some things, Linda, on the phone numbers. We've always kept the phone number of the firm, the solo practitioner, and our phone system works. We have 4 offices now, and but if you dial any number for any of our offices, it all rings at one office in New Richmond. And so through the technology, I'm not quite sure how all that works, but it works. So whatever number you dial, it comes to that one person, and it switches over to different parts of the day, but it comes to that person. So, and to me, the phone number is one of the critical things. If you got a sole practitioner, you want to have that number because people have got that number in their cell phone or wherever they've got it, and so you want to have that number. And then with staff, every time we've done it, the staff have come with the lawyer. And as I mentioned before, the staff are critical to getting the work done. They have the relationship with the clients as well. The staff has always come with us. And as far as the website and that has not really, because at least the folks that we merged with didn't really have much of a web presence at the time, so it didn't. That wasn't something that we had to deal with.
Although one thing I have found is that people from years ago find me just by putting my name on the internet, and so they're kind of surprised to say I'm not in Elm Grove, I'm in Waukesha, and that I'm with this other firm. But then they call me and ask me about it. But they all find me on the internet basically.
And just a comment to that, I think, well, when we open a file, we ask the client how they got to us. And 85% of our clients consistently, we've been doing this for, I don't know, several years, but 85% of our clients get to us from they were a client before, or another client of ours referred them to us, or another lawyer referred them to us. Of that other 15%, kind of the new clients, almost 100% of those folks got to us through the web. They check us out, they look at our website, they look at that, and so that was just interesting as to how people get to us. So we also explored merging with the firm. We were interested in doing that in part because of our difficulty in finding new lawyers recently out of school to come to our part of Wisconsin, northwestern Wisconsin. We're about 20 miles, the Richmond office is about 20 miles from the Minnesota border. And there's a psychological thing, and people who've heard me speak before have heard me talk about this, is that anybody who lives in Madison, Milwaukee understands that Wisconsin ends at Wisconsin Dells. And they're not quite sure that there's any internet or paved roads north of there. And so it's really difficult to get those new lawyers who are tech savvy and like to have things happening around them to believe that there's actually that possibility where we are located. On the flip side of that, for those lawyers who are in the Twin Cities area, I happen to live in Baldwin. I can be in downtown Minneapolis in 45 minutes from my house. Okay, but the lawyers who work in downtown Minneapolis, when I'm dealing with them, and frequently I do, we have to do something, there's a deposition or something out at our office, and they're wondering, so should we do this at one? Because I think it's probably was 3 or 4 hours to get from the Twin Cities out to western Wisconsin. And so, there's those psychological things. And so that contributes to our difficulty in finding lawyers from the schools down here or the law schools in the Twin Cities. But so we thought, okay, well, we're continuing to try to do that, but we're having a struggle. So we were looking to figure out, well, let's find somebody that's already here, that's in our area. And so we then started to kind of go through our contacts and who everybody knew. And, again, unlike the lawyers in the Twin Cities who practice a certain way, I believe, because they're convinced they'll never cross your path again, the lawyers in our part of the state practice a different way because they know they're going to cross your path again, and they know if they do something that everybody in the bar is going to know about it, and so it's just a different practice. So we decided on a firm, and so. As lawyers do, we decided that we would begin that discussion. First, we called them, and we decided we'd do that discussion at a drinking event. And so we all got together just socially, just to have some drinks and hors d'oeuvres and talk about things. And as we kind of knew, because we were familiar with these folks, we were all compatible in that everybody kind of liked everybody. And so after that, we decided, okay, let's look at this and let's explore whether this will work. And so there were 2 lawyers from that firm and 2 lawyers from our firm, and we just started to meet on a monthly basis, about a monthly basis, and we did that over a period of 6 months. And we talked about all of the things that Linda's firm did, and we went through those, and we had confidentiality agreement, we exchanged financial information, we exchanged how we compensated people, we went through all of that, and then each time we met, we went back to the other, our firm happens to be a corporation, so we went back to the other shareholders, they went back to their partners, and they talked about it, and then they'd get some feedback, and then we'd come back again, and we'd talk about some other issues. And anyway, we did that for, I think it was 6 or 7 months. And at the end of that time, what we decided was this. We still everybody still liked everybody. We decided that it had been a good process and a good experience for both firms on both sides. We both decided we would look at doing things internally, maybe a little different as a result of those discussions. And but ultimately we decided 2 things, I think. Really, well, one thing. The thing that we've talked about, culture. And it just kind of the way they did things and the way that we did things just wasn't gonna work. And and you learn that over that time period, that 6 months, you learn, and one of the telling factors, I think, with respect to that was a question that was asked, well, how do you guys, you're in multiple offices and they're separated and they're in different towns, and how do you guys stay so together? And we are in multiple cities, and we have a monthly office meeting, and that rotates between the Richmond office and Menominee office. We do it as a conference call. We have an open forum in which everybody in the firm is in on that call, all the staff people, all the lawyers. We have topics that are in that section. And then we have the lawyers part in which the staff is not in on that call, and it comes right after it, and we go through all that. And so that's one thing that keeps us together, because we're doing that. The other thing is that my philosophy is we're not going to practice in an area in which only one lawyer's in that area. It's kind of my fear of being a solo practitioner. For a long part of the time at the firm, I was by myself in our Baldwin office. I was the only lawyer there. I could have practiced on my own. I had no desire to practice on my own. I understand that that's the majority. For Tom Schumacher, that is just way too risky, and I'm not smart enough to keep track of all that stuff, I don't think. So if we're practicing in an area, I want at least 2 lawyers that are in that area. So somebody can beat you up about what you think is the greatest idea on how to win this case or how to solve this deal or put it together. I want somebody to, critically look at it and say, wait a minute. In fact, I just had one of the lawyers in our firm, his son is graduating, he's in journalism, and I gave him, he worked for us for the summer. I gave him a set of documents that I was working on. And I said, our goal is to have our documents be plain English. And I know you are a journalism major, and I understand that you know nothing about law, really, but you've done a great job for us. Everybody thought, in fact, he's looking at going to law school, and one of the reasons he clerked for us or worked in the office was to see what this is like and do I really want to do this. And so I gave him these documents. I gave him the outline of I said, read this and tell me what it says to you and whether it makes sense. That was the best review of my documents that I've ever had. First of all, because he writes much better than I do, and he got it so that it was plain English and somebody understood it. So we always have multiple people working on files. They may not be totally responsible, but we're always calling somebody up and asking about it. And we have half transactional, half litigators, so we're always going back and forth when one of our business clients gets in trouble or had too much to drink or doesn't get along with their spouse anymore. And, and on the litigation side, business disputes, and it goes back and forth. So, and our divorce clients then need estate plans, and so all of that works. So we're back and forth all the time. And this other firm was in one office, but they were more silo in that one office, and that was the culture part of it. And we didn't think, and we talked to them about that, we didn't think we could overcome that piece, because even though they were all together, they were really practicing independently, and so then that led to how their compensation worked and stuff like that. So that culture just wasn't going to work. But as we all agreed, it was a great experience. It was great for both firms to do that. We changed some of the ways that we were doing things because of comments that they made about, why do you guys do it that way? And I don't know that they did, but I think they probably made some changes on their side as well. So it was a benefit, but it just didn't work out.
Was the silo culture a function of the practice area, do you think, or was it just a work style?
I don't know, and I don't know if that was they had people that were transactional, and they had people who not as, I think only two maybe main litigators, but even the people that were on the transactional side, it just didn't go back and forth as much. I'm not quite sure what caused that, but it was definitely there, and and maybe that was influenced, I could see that as much from how their compensation thing worked too. Ours is, as they would say, much too complicated, and I get it because I'm the one that kind of manages that part of it. And but it was just, even though we have shareholders, our compensation in our firm anyway is pretty much like a partnership. And even though we have various permutations and combinations how we get to the numbers, it gets, at the end of the day, it gets to be pretty much equal. And a lot of times it's difficult when you've got litigators who, are going to bring in some significant money on some cases, and you got somebody else here that's doing municipal law. Dean talked about doing that. Municipal law, we might be doing at almost 50% of what our normal hourly rate is, because everybody else is doing that, and you got to compete with the market. And so, our system, deals with the fact that maybe they're bringing in a lot of money, but they may not be doing that every month. And, I got to pay for the lights and the staff and your salary every month. And, so it mitigates that as well. And so but it's complicated to do that. And, it's much easier to say, well, you're just getting this amount and we'll divide this pot at the end. And,
Plus, you're really discouraged from asking other people if you can't bill for it.
Right.
And so that was the one thing I learned really quickly in my firm, is if I went into another associate's office and said, can I talk to you about this? Next thing you know, the partner would be calling me in and say, who authorized that other associate to bill? And so that culture's hard.
And again, part of what puts us together is that, if I got a no-fault, slam dunk, personal injury thing, is $1 million, I have absolutely no incentive under our system to keep that. I want to get that out of my office as quickly as possible, right down the hall, or actually to the different office, to somebody that knows what they're doing on that, because even though that might seem like the case up front, I have probably got 1,000 ways to screw that up. And so our system really, if it was something that was a lot more, like I describe, an eat what you kill, that doesn't encourage that. And so our system was much more like that, ties us all together.
And I guess I would open the next question to the whole panel. We talk about a compatible culture, and we've mentioned, sort of administrative concerns, compensation, and otherwise, practice areas and work habits. What other considerations are there, and are there practice areas that one who's looking to merge should look for in other firms to merge with, or in some to avoid?
Well, things that we have appreciated moving to a larger firm is that it is divided into different groupings, and the groupings have chairs and they have regular meetings, and it's a real learning experience, and you have someone to turn to as to how does the firm do this. And so having good organization is very important, because certainly as almost a solo practitioner, I did things my way, and now I have people to turn to and see how they're doing it. And the other thing is, we knew we were joining a firm where they had really strong people in the HR and the PR and the IT, and that there'd be a lot of backup and infrastructure, and that was really important to us, that it was a very organized setting that we were going to, and we were much more comfortable knowing that, because we knew that we were no longer in charge, and we wanted to make sure that there was a really good foundation, that it would be easy for us to move into it. And the training was good for our staff, and the systems, the software that they had were things that everyone was very comfortable moving into, and that they kept up constantly.
Just on a culture thing, the fact that Linda and Hector were willing to say, okay, we're willing to adopt your system, that it doesn't have, even though Linda's been doing it her way, they were willing to step back and do that. That's a cultural thing. You could have somebody said, well, we're going to come, but I don't care that's the way that you guys do your estate plans. I got this format, and I'm going to do it, and this is how I create it. That's culture, and you've got to have a willingness to be able to say, oh, I'm willing to do it that way. I'd be interested on the IT side and how that all worked for you folks.
Well, certainly, in estate planning, we have now a big document assembly program, and we have meetings where we work on that, and we've got attorneys probably who came from 5 different firms, and they all lend their ideas, but they're all receptive to, let's have the best product that we can. For the IT, they have really a group of about 6 people, and so 24/7, we can call on them for assistance. And even though we're in Waukesha, they're right on the phone, or they come out, but mostly they jump onto our computer, of course. And for us, that's really phenomenal. Rather, the guy that we called and he's over at Fiserv somewhere else and can't come for 2 days, and we got a real problem. It's just wonderful to have a dedicated IT staff working on that.
Again, from a cultural standpoint, a comment that Linda made, so we've got 5 attorneys coming from 5 different firms working on estate planning, but everybody's willing to contribute their ideas, and then at the end of the day, everybody's willing to, whatever that decision is made on the language and what that means and how that works, is willing to say, okay, now we're all going to do it that way, as opposed to, we've got 5 people from 5 different firms, we all have this meeting, there's that, and then but I have my best form, and I'm going to continue to use it, type of thing.
Yeah, I guess to a certain extent, maybe there was some relief in handing over the HR, the PR, the IT, those duties. Yeah, okay. You can focus on being a lawyer then. Mm-hmm. Yeah.
And particularly for solos and small firms, it's unbelievable how much time administrative things take care of, or take up, and the ability to hand that off to somebody else and have that, I think that's got to be.
Yeah, when you're thinking about cutting down your time so that you're not practicing quite as many hours, and you're having to think about who's making coffee, and when are we going to review this person, and all the details of running a practice, to get rid of all of that and to be able to say, I'm going to close the door and go on vacation next week, and just let everyone know, and you leave your away messages. much more easier, with a larger firm. And so that has worked out for us to say, moving in with a smaller firm, it might not have happened, but moving into a larger firm, it did happen very easily.
One of the things that makes this conversation so difficult, and it's something that Michelle asked earlier, is there's all these different kinds of relationships, and you want to be cautious. Like, for example, let's say, is it a merger when Michelle takes her business practice and says, you know what, I have this specialty, and I'm going to be specialty of counsel to another firm. What does that mean? Well, we know that of counsel means that you have that close relationship so that all conflicts will be imputed. And even people who say they're a specialty tax counsel, when they're of counsel, guess what? All the conflicts get imputed, not just the tax ones, everything. So in that sense, you still are of counsel, you have that specialty, but then what is your corporate structure at that point? It's not a full merger, right? So how do you, then all those rules that apply, basically confidentiality and how you want to pay your people, all that comes into play, and that's contracts and negotiated. So that's what makes this so difficult. Or are you going to be a contract lawyer for those? And that's even a worse field because there's no real understanding of what a contract lawyer is. You can be just for a couple kind of cases, or you can be temporary for 6 months or a year. So you could actually go into that firm for a year as a contract lawyer, keep your business, and still have your own business, but wind that down and transition out. So there's all these different ways, and I think it's hard to pick one. And as Dean said, what that one lawyer who was of counsel to a number of firms, you're a conflict conduit. Basically, all those 3 firms are one firm for purposes of conflict, so, yeah.
Just, talking about how the world changes, and as we talk about this and selling a practice and merging a practice, we're thinking of the typical deal. You've got bricks and mortar and people and all of that. And I've had occasion in the last year to deal with 2 different firms. Both they had the same scenario. These lawyers are spread all across the United States, and they have a firm, but they, the one firm it was a business firm, and they did transactional work and M&A work, but they had, I think, 15 lawyers spread across the United States, and they're all sitting in their spot, or they may all be sitting at the lake, or they may all be sitting in an office or whatever, but they come together and they do deals, and they have their components of that, and it isn't a bricks and mortar type thing. And I had another one where it was involved in Indian law. My brother is a lawyer out in Wyoming, has done Indian law all of his life, and he's involved with some lawyers, and again, they're spread across different they're kind of western and southwestern part of the United States, but they're in a firm and they're just connected, through the agreements and the contracts, and they have those conflicts, but they're primarily in one specialty area, and they don't have a regular office meeting, I can tell you. They may do some video conferencing, but they're spread across the country, and that's how they practice.
And I would say the opposite is the firm that I joined, Von Briesen, is now 190 attorneys, but we just had our summer picnic at Lake Park Bistro in a tent. And we have a Christmas party, and it's not just the attorneys, it's the staff and all the spouses, and somehow they pull it off. So they work very hard. When we have any kind of meeting, you can come in or you can teleconference. And so, we're working hard, and every meeting, the president of the firm talks about culture, talks about values, and so it's constantly tying it together, because we do have, quite a combination of some larger firms as well as, smaller practitioners who've joined. And so they work very hard to make everyone comfortable, both socially, but also to know, what the values are of the firm.
One of the things you talked about being in different states, we really have to worry about 5.5 because that's our, multi-jurisdictional practice and unauthorized practice of law rule, because many jurisdictions have the rule about where your butt sits. And unfortunately, that's the expression, I didn't make that up. But if there's 4 jurisdictions right now that have exceptions to that rule. But if I'm in Wisconsin and I'm doing Illinois law and I'm an Illinois lawyer and I'm only working on my Illinois clients, but my butt is sitting in Wisconsin, I may be engaged in the unauthorized practice of law in Wisconsin, the way those rules read. So you just want to be careful about that jurisdiction's rules, because when you're looking at merging practices or allowing your practice to be merged into another one, that's another rule you want to look at. So thanks for bringing that up. I didn't include that in the material, but.
Okay, in the last couple minutes, do we have any questions either from the audience here or on the web? Is Joe still here?
He is.
All right. I think we'll wrap up. It's 10:55.
But I do
Oh,
have in the
one more.
materials an outline about different business relationships. So if you have any questions, you can look at that. I have of counsel, contract lawyers, sharing space, all sorts of things that you want to think about. So.
Okay. So we'll be back at 11:05 for the third panel. Thank you.
All right, hour number 3. Thanks for coming back. Those of you on the web, if you have questions or comments, keep them coming. I think as I watched Matt introduce himself, I realized I probably hadn't introduced myself at the outset of the morning. I think some of you do know me. I'm Tom Watson, Senior Vice President at WILMIC, so that's me. And so, last hour of the program, we are going to focus a little bit more on closing a practice for this hour. And we have one new panelist with us. To my immediate right is Steve Sorensen. Steve is at Von Briesen. He is a shareholder with more than 35 years of experience helping clients with a whole range of legal issues, really. He provides counsel on corporate law, business succession planning, estate planning, and he also represents municipalities. And with regard to real estate, he counsels on land use, zoning, smart growth, waterfront litigation, and non-metallic mining. Those are some very interesting areas of practice for sure. Steve is also past president of the State Bar several years ago. So Steve, welcome, and thanks for being with us. I think we'll start this hour, and again, if the web viewers or anyone here in the room have questions that kind of are spilling over from the previous panel discussions, that's fine. We certainly can try to take those up as well. But as we start this panel, in terms of closing a practice, Steve is also very active, as Dean Dietrich is, in the senior lawyers division, and this is the succession planning topic is one they've been working on for a long time, and I know it's something, Steve, that has been an issue that you've been working on, and part of it is the personal transition, how to stay active and stay fit and be in a position where you can make good, informative judgments and decisions as you transition out of practice, and I thought you might want to talk a little bit about that.
Yeah, I mean, I bring some kind of a weird situation together if you look at my practice, because I have come close to closing my practice 3 times. Once when I was elected president of the State Bar, and anybody who is in a small rural practice at that time with 4 attorneys would find out when you become a State Bar president, that's like a job, and your practice kind of goes away when you're not looking, and those 3 associates are now 3 attorneys in town competing against you when you get back.
Michelle's smiling. She knows exactly what that's like.
So you know, that was my first transition, and then to come back and rebuild the practice after being active in the bar. The second was I had a good friend, his name was Scott McCallum, and he asked me to come to Madison to help him because he was about to start his career as governor of the state of Wisconsin. It was a very short-lived career. During that period of time, I took over a state agency, which I thought was going to be my career, and when he was not reelected, because the Senate refused to confirm any of us during his term, I had to come back to a community where I had thought I'd close my practice and start over again. And then about the time I remodeled my office, I doubled the cost of what that office was in a small town, Ripon, Wisconsin, because I just really thought the office was becoming dated. I thought it was inappropriate. I had to do some things, so I spent a lot of money remodeling the office, thinking that my transition plan would be probably 10 to 15 years. I would have some associates come in, buy me out, buy the practice, life would be wonderful, and I would fade into the woodwork, so to speak. The reality was 2 years after I had it done, I got a phone call from another firm saying, wouldn't you like to join us? And I will honestly say they made an offer to me that I couldn't refuse. It was more money than I was ever going to make as a solo practitioner in a small town. It was less liability in the sense that I didn't have to worry about snow shoveling and mowing lawns and all those things that you do when you're in a solo small practice or a small firm practice. The big thing, and this is getting around to your question, is I had, at that point, I had 7 employees, 4 of whom were lawyers, 3 of whom were non-lawyers, and my commitment was I would not leave this practice and go to this job I was offered until everybody had a job, because I was considerably older than most of them. And so the transition for me was to find every single person a job that would sustain them into the future. One attorney came with us. That was the one I couldn't find a job for. And I basically told the firm I was going with, he's either coming along or I'm not coming. And we made a deal and it worked out. And now he's one of the biggest producers in our office, probably outproducing me now. So it was a good move on the part of the firm. This one, I found a job with industry. She went to become the in-house counsel for one of our biggest clients. And the fourth attorney, I happened to be chairman of the hospital board, and we were looking for a hospital board corporate client or corporate counsel. And I said she'd be the perfect candidate, and everybody agreed. And then the staff, one, I found a job with another law firm, another president of the bar, Paul Swanson. One came with me, and the third one, I was able to work with a local bank, and she went there as a customer service officer. So that's what the personal side. And I think when you live in a small town like I did, Ripon, Wisconsin, and Green Lake, I actually live in Green Lake, but I worked for 40 years in Ripon and lived in Ripon for 38 years. The reality is you have to keep that community and the people that you had worked with and they built your job, you've got to keep them happy too. And you have to do that in a way that the transition is effective. And I really felt very good the day that I said adios to, Sorensen Law Office, and welcome. At that time, we were with Davis and Kilthow, but we soon transitioned to Von Briesen and Roper, which my experience a little bit different than Linda's, but we could talk about that some other day.
No, wait a minute, let's talk about it. How was it different?
Well, you have to remember, first of all, I came out of a practice, which was a small firm practice, which I brought over 1,121 clients with me to Von Briesen. I'll never forget the day the IT person came in because he was going to spend a half hour downloading all my files. After the third day he had been at the office downloading the files, he finally said that there's got to be a better way. And what I think a lot of people don't realize that are in large firms, that if you come out of a small firm and you're making a living doing deeds and transfer returns and contracts with the local kennel to kennel dogs or whatever you're doing a ton of work for a ton of people, and you're going to have lots and lots and lots and lots of clients. You might have one or two or three really good clients, but the vast majority of your work, not necessarily your pay, the old 80-20 rule probably fits. So it was different. And then, of course, to come into a firm that has processes and procedures, and you've been a firm or you've been practicing where you set the rules, you're always in control. It's very difficult for someone who has been practicing for 10 years and you've been practicing for 40 to have that person come in and say, this is the way we're going to do it, and you're going to do it this way. Excuse me? I did the seminar last week on special needs trusts, and you're going to tell me that I don't know what I'm doing when I'm doing a special needs trust? And that's why I was really happy to hear that Linda's experience, which preceded mine by several years, well, a few years, into Von Briesen was different. Because I think one of the hardest things for those of us that are solo smalls who have a huge practice, who have 40 years of experience or 30 years of experience, is exactly what Tom was trying to identify as culture, and to have a firm say to me, you don't know what you're doing, when I just gave a seminar on that topic a week before, didn't sit well with me. Now the good thing was I went to management, higher up management, and said, I ain't gonna work. And the president of the firm said, you're right, that's not gonna work, let's work it out. And it did work out. I think that's the other thing that is different. The other thing that's different about is there's not a lot of reality checks for people that have practiced their entire career in an urban area to what it's like practicing in a rural area. The two of us will have conflicts often about what conflicts are, because I don't live in a textbook and I don't live in a perfect world. I live in a real world. I live in a world where you live in a town that you're going to go to church with half of your clients. You're going to go to the grocery store with the other half of your clients. In a given day, not so much anymore that I'm with a larger firm, but when the day, I would see probably in a given day 70% of not only my clients, but the person on the other side. And I had to interact with them. I mean, I remember once sitting in the pew, so to speak, at church, knowing that I was suing the minister. You know, and I'm sure that if I were writing my textbook, I'd say that's improper, because that will sell well in law school. But the reality, and I'm sure Tom's smiling because he probably could, you know, if we can go to some of those towns like Baldwin, you can see it happening. You politely say to the minister, it's nothing against the church or what you're saying, it's just, you know, it's my job. He left town, that's okay. But the bottom line is that that's one of the issues that you have when you transition out of these solo and small practices, and you've got to keep this relationship in the community. And so I tell you that's one of the factors that I don't think get talked about very often, is the fact that you have to live in a community. I once told a group of lawyers when I was giving a presentation, I think this was out in Iowa, with solo and small practice presentation, and I said to them that one of the things you're going to learn is after you've practiced for about 20 years in a small town, you go over the cliff. And they said, well, what does that mean? That means you've sued half the community and it's time to pack up and leave. Especially if you do family law or things like that. But the reality is there's always another half coming in underneath, so you're going to be okay. Just got to find younger clients. I know I'm talking too much, Tom.
You're like Clint Eastwood in those old spaghetti westerns where you got to leave town. Well, so yours was very sudden. I mean, we've been talking all morning about how planning is so important, and that's the best way to do this. But it sounds like your move from your solo practice to the bigger firm came about rather quickly, and you hadn't had time to really plan and put all your ducks in a row. Is that fair?
That's absolutely correct. We did it in less than a month. And the key is, of course, not one single client got left behind. I mean, they were all my clients. My building stayed there. You know, the phone number stayed there. I went there at least 3 days a week for a period of time to allow for the transitioning. Again, my rule was I'm not going to leave these people high and dry. I spent probably as much time, Tom, finding other attorneys for people. I mean, one of the things that lawyers don't recognize, we're going to talk about closing your practice, is you have a duty under the rules to find somebody for that client. You can't just walk up to a client. You know, I love the presentations that are given that every year you should fire 20% of your clients. That's a good rule. I love that rule. But the problem is you have to find a substitute for those 20% you just fired. I mean, you can't just say, you're done, I'm done, clears the door, I'm closed. Under the rules, you have to transition those clients. And a lot of people forget that, and they don't have a system in place, and they don't do that. So one of the things about closing the practice for me or transitioning into a large firm is I couldn't do the large firm stuff and do the small firm stuff, so I transitioned to many of your clients. Now, the lucky thing I had is I have 27 people who were associates of my firm over the 40 years I practiced who are now competitors of mine. So there are 27 lawyers out there that I educated in the 15-mile radius that I could simply say, well, you can go to Ludd or you can go to Tom or John, because they're all practicing in the area, and I knew those attorneys and I knew they were well trained. But that's a responsibility that a lot of attorneys when they close their practice, don't look to. And you really do need to look to that. You really have to look to doing that. But you're right,
So let
Tom.
me,
I did it in a hurry.
So under 1.16, so SCR 20:1.16D, the lawyer, when that lawyer is terminating the representation of the client, has an obligation to take all steps reasonably practicable to protect the client's interest. So we usually tell lawyers that that doesn't extend to actually finding another lawyer for their clients. I mean, generally speaking, you would say, I can recommend somebody, or I can recommend several lawyers that you can choose from, but you don't have that responsibility. Now, that's under the rules. So I'm going to distinguish between under the rules and what it means when you're living in a community and you're still going to be part of that community, and how those former clients are going to feel if they're left high and dry.
Yeah, and the other aspect I put to that is, now I'll put my state bar hat on, having been president of the state bar, you have a duty to the profession. You know, to me, that supersedes many of the rules. You have a duty to the profession, which means right now lawyers have, in many cases, a bad name. And if you abandon clients or simply say, you're going to have to find, here's the list of attorneys in the area, I don't think that's being a professional. And that's one of my watchwords. I mean, I will never be a non-professional. I mean, I had a client that used every four-letter word, and I finally said, I can't represent you. The only client I've ever terminated. And I
His
mean,
representation he terminated, not the client. Just want
no, you misunderstood me.
no statute of limitations.
You'll never find his body. No, this seriously was a client that just couldn't use the English language without four-letter words, and it's just part of my mentality. I can't handle that. I've walked off golf courses with people that won't clean up their language. And the judge said, "Why are you terminating?" I said, "Because," and he said, and I'll make up a name, Mr. Smith. And then when he called the judge an SOB and told him where he could put himself, and Judge, I understand, Mr. Sorensen, you're dismissed. I mean, and by the way, if you say that in my courtroom again, but getting back to your other thing, Tom, and I think what you really were asking me about, and I would tell everybody this, one of the other things that I learned really, really quick is when you're looking at closing down or changing or transitioning, a lot of times people forget about themselves. They forget that mental health and physical health are probably the most important characteristic. I'll spring something on Linda, who's with our firm, which she probably doesn't know about, but we're working about a new program at Von Briesen, which is going to be, how does one transition out of the practice of law? And one of the big things that I'm putting together is, how do you physically and mentally transition out of the practice of law? I mean, how do you one day say, I have a place to go and I have purpose in life, and the next day say, I'm just a gardener for my, my wife or my spouse or whatever. And that's not, shouldn't say it in that tone, but the reality is, I watch way too many lawyers not necessarily burn out, but physically destroy themselves because they don't take care of themselves. They let their body and mind go, and then they get to a point they have no alternative. And if you stop sometime along the way and say, I better get myself healthy before I retire, that's really important, because being healthy before you retire, being healthy when your firm's still paying for the insurance, being healthy when you still have a source of income that's fairly, dependable is really, really important. Tom knows I work in the WISLAP program too, and a lot of times dealing with senior lawyers, and senior is not a negative word, because we now have super senior lawyers. And then we're going to develop a new group called the super senior lawyers. You know, that's instead of having this emeritus status stuff. We're going to give you different titles like they do in golf. Yeah, I finally was able to use the upfront tees the other day because I was on the super senior group.
Well, I learned that I can get half price on Brewer tickets. So, at 60.
Really?
Yeah.
How old do you have to be?
Wednesday afternoon games, senior day.
Just got to have,
You got to be 60.
I'm 66.
Well, there you go.
it goes away at 65.
See the things you learn at our seminars.
But my point is that you really do need to take care of yourself too, because as one lawyer said, he transitioned, he finally got to the point 84 that he was going to call it quits, and he discovered that calling it quits was just going to be sitting in front of a TV set and maybe reading the Wall Street Journal and taking care of his wife because she was not in very good health. And that's really why he was quitting, is because she wasn't in good health. And as he said to me, he said, if somebody had given this speech that this was at the senior lawyers thing that you just gave, when I was 60, my wife and I would have gotten in shape and we wouldn't be in the situation we're in now. He said, I might have still worked, but I would have gone to the gym and I would have done things and I would have made a change, but nobody ever talked about that. And so I'm here to talk about that, Tom, that's important.
Okay, good. We have a question from a web viewer to Joe, and in light of the conversation, the viewer asks, Joe, do you run into situations that Steve described in which a lawyer is suddenly faced with closing up a practice rather quickly without much planning, and how do you handle that, is basically the question.
Yeah, so I get to hear all those different types of, hey, I'm planning on closing. It's interesting to me, the folks that think they're planning, they're sort of looking at July 1st. I don't want to pay any more dues to the bar, so I'm going to quit. I'm going to give up my license. Or the end of the calendar year, I'm going to stop paying taxes, all that sort of thing. So they pick out dates on the calendar, and that's part of their planning, and that's completely fine way to approach that piece of the plan too. But the hard ones are the folks that get a diagnosis medically that, okay, I can't continue to do this. Whatever treatment I'm going to go through, I'm going to be so tired I can't even keep up. Or somebody has a stroke or a heart attack that is debilitating and it's a sudden stop. So we run into that all the time. That's why at the beginning of the day, I took off of Dean's comment about deliberate thinking and creating a plan. It still does happen out there. Know that there are resources in the bar and your communities that folks will come in and pick up the ball if they have to, as Tom has done. But better approach is to sit down today and think about it, or this weekend and think about it. There's all sorts of checklists out there that we talked about in one of the breaks that will at least give you a starting point of the things that you should be addressing or at least trying to plan for. And it's amazing sitting here and listening to different folks talk this morning, all the different facets of this, from the simple, what do I do with my telephone number? What do I do with my old building? How do I do that? It's that broad, and it's that important too. I've talked to folks who've left Madison, gone back to their small town where their dad was practicing, and they walk in and they're looking things over, and they pick up the phone and they say, Joe, I have 40 years of files in the basement of the house. What do I do? We used to say just store them and keep them safe, and that's not the case anymore. We're scanning stuff in so that digitally we can get to it. So that piece of it, all of that is transitioning. So it's multifaceted, and none of the facets are easy. But if you sit down and do a little bit of planning, it gets you way ahead of the game. You can't answer every question, but if you can answer the ones that are there, it gets you further down the road and puts you in a better place.
You know, the first thing in that planning step, there's a list in the back of the materials, and it's I apologize, it's Lawyers Mutual, but yours is coming out and it's going to be better, Tom. But it's a list of contacts. So how many of you right now in your personal lives, do you have a list where somebody can say, here's all my insurance policies, here's all my credit cards, here's all this stuff, right? So that your family can get it. Do the same thing for your practice. You have it?
There is a book called I'm Dead.
Yes.
What? And it just goes through and asks you all those questions. Who's the financial planner that you have?
Right.
Which banks are they located in? What's the contact information? What do you want in your obituary? Where are the accounts? Where are the numbers? Where are the passwords?
Yep.
It's really good. It was $25 on Amazon.
Yeah, I saw that. It came up in my search for some reason. I was like, I didn't know quite why. Right after my birthday, it came up. So I was like, okay, you're dead. So that's a great place to start, because at least if there's an unfortunate event, that information is available.
Let me pick up, because let's talk some reality. What happens when you do have that heart attack, or you do have that stroke and you haven't done the planning? Two things that, and I've gone through it with 7 lawyers that I was thinking while we were talking, 7 different lawyers I've worked with who have had an unfortunate occurrence in their life. Those of us that practiced for years, and I really still do practice in small town America, there's always a lawyer that's ready, willing, and able to come in and help. And the Supreme Court has really allowed that to happen. So what you really want to do is you want to tell your significant other, whether it's a spouse, whether it's a parent, whether it's a friend, because we don't all have the perfect relationship, but tell them that you can contact the bar, or you can contact, because the reality, I had a young lawyer, well, young, I think of him as young, he was in his 40s, that was killed in a car accident, and he was a solo practitioner. And his assistant or secretary called me and said, what am I going to do? And I said, I'll be there. You just go and you look at the files, and the 5 or 6 attorneys in the area that are willing to come in and help. You organize this. And I think if you're in a solo or small firm situation, that's good. Obviously, if you're a government lawyer, they've got somebody else to fill in. You're in a large firm. Linda and I think we're extremely valuable, but if we're gone tomorrow, I know our work will be paired out to somebody. They may not know what they're doing, but couldn't do it as well as us. But the reality is it'll get done. There's protection. It's when you're out there in that world of solo and small that you really do need to at least tell your family and friends. And I'm telling you, it works, and I've seen it work. We had a lawyer up in our area that loved his cocktails, and we all knew someday something was going to happen, and it did, And so we all went in, we piecemealed his files, we took care of it, and it works. And I think that's kind of a message I would give to everyone. Now, I'm going to flip that for a second. Be the lawyer that's willing to do that. Some of you are looking at transitioning, and you're in a small town, but you just don't want to work all those hours. Don't be afraid to go to the court or go to the bar association and say, hey, I'm moving up to Minocqua. I'll use that as an example. That's where half the lawyers in the state of Wisconsin are right now. I'm always amazed by the number of lawyers that say that's their. But anyway, the reality is, if you're going to an area, I'll pick something much worse, you're going to Crandon. Forest County has 2, I think they have 2 active lawyers now, and that's on a holiday weekend. But the bottom line is to go to that judge and say, Judge, you need somebody. If something happens up here, call me. And I'll keep up. That's the other thing you have to do, though. You got to keep up on your practice. You got to keep up whatever happens with this emeritus thing, we'll worry about that some other day. But the bottom line is, I think that gives you a good career, and it's a great option for leaving the practice, is while you're closing your practice and migrating to a part-time practice, which I call the fadeaway instead of the quick close. The fadeaway is a great approach to closing your practice. And you can do that in such a way that you can be helpful to your profession and to yourself.
So I just want to add a different perspective, because on the hotline, between WISLAP and hotline, we get so many calls of lawyers who have died or become incapacitated in their practice, and we can't find someone to be a Chapter 12 trustee. And it is so painful for those communities. And there are times that lawyers just disappear and all their files are there. Well, the lawyer that's coming in to volunteer doesn't have the money to shred those files. And if that ever comes up, pro bono does have some funds available to pay for the shredding. But the amount of work that those volunteer lawyers have to do under Chapter 12 is just immense sometimes. So, and there's usually no money in the practice at that point to pay for it. So, whether you have that succession planning, whether, we have that succession planning registry, think about, a power of attorney for closing a law practice. One of the things that come up is that there's no other signatory on the trust account. So there's client money in there, and so what has to happen? They have to find a lawyer to go to court to get a court order for them to get the money out of the trust account. So having another signatory on that trust account to help out, there's lots of things you can do. So our experiences are different, and I think it's true that in some communities, lawyers are willing to help, but we're finding in a lot of communities, they just can't, or there aren't the lawyers there to help.
A couple of web viewers jumping in. The first question I have from the web, and Tom, I'd be curious on your view of this as well as Stephen, maybe Aviva and Joe. Any suggestions for bringing another attorney into a firm to take over as an attorney is preparing to retire, as opposed to that attorney merging into another firm? How do you identify that? How do you reach out?
Yeah, I think that I've done that 27 times. I think what you have to do, the best thing to do if you want to bring in a rural area is you want to find somebody that has some connection to your community. The worst thing you can do, and Tom, you'd experience it out of the Twin Cities, I'm sure, they can't find a job, so they'll come out and work for you until they can get a job and go back to the Twin Cities. We get the people from Madison that can't get a job in Madison, so they'll come up to, Green Lake or our area until they can find the job they've been looking for in Madison. But if I have an attorney, and I'm looking at one right now, trying to help the city of Ripon get an attorney, because we've gone from 11 to 3 now, is go find somebody who is in law school who has a connection to your community, or who is in undergraduate school and is interested in law. I happen to be the pre-law advisor at Ripon College, and I've already identified 5 lawyers that are going to go to rural Wisconsin once they graduate from law school, and they're juniors or seniors in college right now. Now, I know out of that group of 5, if I get 2 of them to really do what they're committing to do, it'll be lucky. But I think that's number one, is to find somebody that has a community connection. The thing I tell people too is the big firms, and we're one, that we're looking for the top 10%, we're looking for the top 20%. When I was a solo, I looked for the lawyer that worked the hardest in law school. I don't care what their grades were. If they put in time on different things, and those are usually the lawyers that are looking. The third thing that I would say is find a position that can also dovetail their significant other, their whatever, with them in the community. Because if you can bring 2 to the community, your success is a whole lot better. If you leave that one in the Twin Cities, and I'll use Tom's example, or if I leave that one in Madison, or if I leave that one in Appleton and bring it down to Ripon, chances are that's not going to work. I have to find a way that the 2 can come And sometimes that means you go to your Chamber of Commerce, and sometimes that means you go to your business community and say, you want another lawyer in this community, here's what the rules are gonna be. You know, we're gonna go, I used to do that when I was on the hospital board. How do you get a doctor to go to Berlin, Wisconsin? And it's pretty tough. You find, you know, her husband a job, you know, and we worked at that. And that's a very successful way of recruiting. And I think that's easy to do. And the other thing is the state bar is waking up to this, and they're putting programs together too that do outreach. But I will tell you that the biggest problem that I see, and I see it because I teach students and I work with students, is nobody ever asks them. They don't know that they can go to Mondovi or Arcadia. They think because everybody in the law school that's teaching them is from a big firm or been a part of a big firm or has been a part of academia their entire life, they don't have anyone sitting there in that law school environment that's saying, yeah, it's okay to practice law in Baldwin, or it's okay to practice law in Rice Lake. There's a great belief. And then finally, the thing that you have to be cognizant of is you can live a quality life in Turtle Lake, Wisconsin on $40,000 or $50,000 a year. And anybody that tells a lawyer that's all you're gonna make, that's gonna crush them. They're gonna say, oh, all this law school debt and everything else. Well, that's another problem that we have as a society need to work out. But I'll tell you, the quality of life in a small town or in a smaller community or where you're your own boss can oftentimes overcome not making, you know, $125,000 a year and working 200 or 2,000, whatever it is that we're required to work if we're an associate in the firm.
Another web question. Pros and cons of maintaining your license after retiring if you have no intention to continue to practice. Any thoughts on that?
I do.
Okay, Joe.
I had an attorney tell me, I ran into him and he said, you gave me the best advice anybody's ever given me. And I said, please record that. I don't get that very often. But he said to me, he said, the question he posed to me was, what are folks doing to protect themselves against going to church, going to the grocery store, running into somebody who you've done work for, and sort of trying to say to them, you know, diplomatically, I don't want to do your work anymore, I'm retired. And I said, you know, I've been told by other lawyers in that position that one of the things that they've done is said, I don't have a license anymore. And he said, I took that to heart. And he said, I've used that a number of times by simply saying, I can't help you, I'm not licensed anymore, but I'll refer you to the folks that I know. So that's one way to do it. Mm-hmm. Yeah.
Aviva, did you have a thought on that?
I agree with that. If you're not going to practice, if you go inactive rather than active, and you can't practice, but if you stay inactive for a longer time, then if you want to go active again to do something, you know, there's all these requirements to go through, like make up your CLE credits. So I would keep that in mind. The thing that I hear from lawyers sometimes, though, is the emotional impact of resigning. Because if you're a lawyer and that license is so integral to your personality and what you do. So when people call and ask me that question, I go through the rules with them and explain active, inactive, or emeritus, and everything that's required. But then I ask, you know, how much of your identity is tied up in that license? And do you want to go inactive for a year just to test it? But then I always remind them, what you say is, look, right now I put my license on inactive. I can't answer your questions. But that's good advice, Joe.
And we heard that at the Senior Lawyers Division Conference, Steve, didn't we? A number of lawyers at that were saying they had no idea what to do with themselves after leaving.
Yeah, and I take a whole unique, maybe, perspective to this. One, I don't think you should ever give up your license until you're incompetent, because you never know when you might need it. Plus, the bar needs some money. It's spoken like a bar president, you know. But the other aspect of that, and Tom, you've hit on it, is unless you have a plan as to what you're going to do once you retire, then I suggest you just slow down. You don't quit. I have a master plan. This is really funny. I pulled it out the other day. I wrote this 6 years ago, and it shows exactly what I'm going to do when I retire. I had to change a couple of words because the job titles are different now. But I actually have a plan. The day that I say I'm not going to practice law anymore, this is what I'm going to do. And I think knowing that and knowing how much work that is keeps me practicing. But the bottom line is, I think that if you're going to quit practicing law, quit. Here's the number one suggestion I would give you. And it was given to me by a person that I respect a lot. Go on a trip. The day you hang it up, you close the office or you say goodbye to your friends and partners, go 6 weeks, 2 months. Just get out of town. Because by getting out of town, you're sending a message to the people that normally would be bugging you and trying to get work out of you, and you'd have to say, I don't have a license anymore. They're not there because you're not there. They'll transition. And if you've prepared them for transitioning, great. If they weren't listening, they'll have to pick it up. But the best thing that I can tell you to do is to not be there. I wish lawyers in large firms would hear this message, because it really is hard for a junior associate or a junior partner or whatever you want to call them to build a reputation with the client when the older lawyer who says he's retired or she's retired keeps coming to work. The bottom line is, if you go away, they're going to move on, and it's going to be there. The other thing is, if you move away, you don't have to worry about because you're not being confronted with it. I wonder what Mabel's doing. I wonder how she's doing. I wonder if that thing got done. I wonder if that land transaction is really going through. Because your mind's going to be full of, I've just got to Estonia and I never knew churches were this beautiful, or I wonder if I can get out of Russia now that I'm here. I mean, you'll have a whole different set of problems. But I really strongly recommend it. And every attorney, one attorney went and walked the Appalachian Trail. You know, what a great way to retire. And I do think that's my plan. My plan is, the day I retire, I will go away for at least, 6 weeks. I mean, some of you may want to know, but I'm going to go to work at Disney. I want to be Goofy or one of those characters. I mean, no, seriously, they hire seniors at Disney, and I think that's where I'm going to go and not practice law. And you can all think of what you want to do yourselves, but I think that's a good idea.
I think with you think financial pressures are part of this too? A lot of solos out there are not making the kind of money maybe they did a while ago, and some of them I think are still practicing because they have to financially, and that can pose a whole set of issues too. They may want to transition out of practice, but they feel like they can't because of financial pressures. Do you guys hear?
Yeah, I mean, that's one of the biggest reasons I haven't quit yet. I mean, I have a building that's assessed at well over, $300,000 or $400,000 in Ripon, Wisconsin. If any of you would like it, it's for sale. I'll make you a deal. But that's a reality for many, many, many solo and small firm practitioners, is they have an office or they have an investment that nobody's going to buy. When I started practice, the rule was, you came in with the older lawyer, you bought them out over time, you bought their books, you bought their equipment, you kind of bought the book of business, but you didn't pay a lot for that, but you bought the physical asset, which really alleviated their debt. And that was their retirement. They didn't have 401ks. I mean, my retirement, and I'll be very candid, I always have been, my 401k, if there is one from my solo years, is an office building in Ripon, Wisconsin, and a lot of books. They're beautiful. They're hardly touched. And 12 computers, a file server, beautiful equipment if it was 1985. But the bottom line is, that's the crux, Tom, and not anybody's doing anything about it. I mean, if I were president of the bar right now, I think we'd have a program where we take money from the young lawyers and give it to the senior lawyers that can't sell their practices, and we go around and buy them all up. And
The
then
young lawyers don't have any money either, right?
Well, some of them do. No, seriously. But seriously, there's no way for a lot of senior lawyers to quit.
Yeah.
There just isn't, because they have no 401ks, they have no retirement, and that's a bar problem that's got to be dealt with. And that's one of the things we in the Senior Lawyers Division are going to tackle this coming year or next couple of years, because we have to find a solution. Otherwise, the solution is malpractice. You just keep practicing until you are doing stuff that you shouldn't, and then some of the rest of us are covering for you all the time.
Well, we don't want that. We're just about out of time. Any other questions, comments? Tom and Linda are still here from the second panel. Anybody on the web left? Katya, you'll be happy to know a web viewer has already purchased your book online, the book you mentioned. So they thank you for that recommendation. So the beauty of technology. You sold a book off the web, so thank you for that. Anybody else? Questions, comments? I want to thank all of you for coming. I want to thank the web viewers for watching. I want to thank Steve for coming, and Linda and Tom for your contributions today, and Dean Dietrich earlier. Joe and Aviva, thank you very much for what you've contributed. I hope you all learned something, and if you have any other questions about this, I know our speakers are happy to talk with you in the future if you have questions or things you want to talk about. And I will mention one other thing before I throw it to Steve. Again, we are working on the succession planning guidebook. WILMIC is with the Senior Lawyers Division. Hopefully have that at the end of the year. And I'm looking forward to getting that out, because I think it'll be very helpful, covering a lot of the stuff we covered today and then some. So I think that'll be quite valuable. Steve, did you have?
Well, I was basically going to pick up what you just said, is that the Senior Lawyers Division is committed to helping senior lawyers. And part of the helping senior lawyers is working on transition. One of the things that in the publication that I put together not too long ago is, when you're doing transition planning, coaching is really a good thing to do. Find a coach, and there's plenty of us out there that'll be more than happy to sit down and help you. That's, like I was telling Linda, that's what we're going to start doing within our own firm. We're going to create a team of coaches that can coach people when they want to transition. There's a multitude of ways of doing that, and coaching is good. Mental health, physical health, get coaching, and enjoy life.
And
One
then
other oh, go ahead,
thing.
Aviva.
So in the materials, there's a checklist about closing the practice. So one of the things that I would recommend in that sort of being deliberate is look at that checklist now, because there's things you can do. For example, people say to me, well, I haven't reconciled my trust account in blank years. And I'm like, okay, maybe you should start. Yeah, I know, right.
No,
exactly. But
that's why you go on that year vacation.
Right, that's right, there you go, that's it. But there's a checklist there, and that will kind of help you work through. There's also 2 ethics opinions about files in there. So if you have 50 years of closed files right now, you don't have to keep all those. So you want to start whittling them down to the extent you can, and so there's guidance in those ethics opinions about how you do that.
Okay. One other web question under the wire here. They would like to hear the comments about going emeritus status versus inactive.
So emeritus status is active. You can practice while you are emeritus. If you go inactive, you cannot. And the problem is that lawyers will often go inactive, and then they turn 70 and say, I want to go emeritus, and you can't do that. You have to go from inactive to active, and then to emeritus, which means if you've been inactive for 3 or 4 years, you have to make up your CLEs, you have to do all these things, and if it's longer, you may have to do other things. So keep in mind, if you're thinking about you're close to emeritus, don't go inactive beforehand.
Well,
I mean,
let's be very, very candid. There's an emeritus committee that's meeting on a regular basis that has already made a recommendation to the board, or is about to make a recommendation to the Board of Governors that's opposed by, that the Senior Lawyers Division has opposed. We have an alternative view on how it should be done. So whoever the person is, I strongly recommend you contact the Senior Lawyers Division. We can tell you what's in the, so to speak, on the horizon, because I think you're going to see a marked change in the way one retires from the practice, either as a part-time practitioner. But the bottom line is people go emeritus, and the biggest reason is because you don't have to do CLE and you don't have to pay dues. That's probably going to change, so be aware of it.
I promise I'll get you out of here, but one other web viewer jumped in, and Aviva, this is for you, I think. The viewer says they'll be closing their physical office within the next year. They still have files that have to be maintained until the cases are completed. If they have to meet with clients after the office is closed, they plan to rent the conference room from an office down the hall, a non-lawyer office. Is there a problem with that?
it depends if they're going to keep anything in that office. If they're going to keep any files in that office and it's a non-law office, they have to make sure those files are secured so that none of those files can be accessed by anyone else. So that can be a file cabinet that's locked that nobody has, access to. Other than that, they can use that rental space. They just want to make sure if they're using that space that they've checked it out so that it's a place where nobody can hear them, basically, if they're doing that.
And make sure that if you're using internet connections, that those are secured and protected, because a lot of the internet services that are in the Regis type buildings are not secure.
All right, web viewers, thank you for your questions. Thank you to all of you and to the panelists. Appreciate it very much.
I'll be glad to answer questions on the hotline, or I'm sure if you call Steve. So if you have anything, just give us a call.
And if you have those evaluations, if you could fill them out, that would be great. You can just leave them on the desk in front, the registration desk there right outside the room.